My remarks follow on part of John's remarks, especially that part in which he thought that while the concerns of this paper might be historically interesting, they are not interpretively relevant. And I would agree with that judgment. And in fact, I would agree with that judgment in a way that is somewhat less generous than John's. I would begin by acknowledging the fact that an alienation from the Constitution to some extent and from originalism to a greater extent is a feature of the intellectual world. So that originalists or the originalist project is not very favorably looked on or looked on with interest by various minorities. To which my response would be, so what? Who cares? I'm a member of, in my other life, or my previous life, I was a Miltonist, a student of the poetry of John Milton, and at one time the president of the Milton Society of America. As far as I know, there are no black Miltonists. There were a couple back in the 80s, but they are no longer on the scene. There are very few black students in Milton courses, at least in my experience. And again, in relation to that phenomenon, I would say, so what? Too bad for them. They would be in a better position in any number of ways if they sat in Milton courses. I guess what I'm trying to say, that the concerns that Christina Mulligan says should be addressed will not be addressed, cannot be addressed, and finally shouldn't be addressed, because they're political and sociological concerns rather than interpretive concerns. And let me illustrate by pointing to just a couple of passages in the paper about which I had questions. On page 15, Professor Mulligan writes, to the extent that white women and people of color interpreted the Constitution differently, these interpretations are less likely to have been recorded and identified. I focused in my intonation on the word differently because I wasn't sure at the beginning of this paragraph whether she was saying one of two things. Either that there were people in the period who understood what the Constitution meant, that is, understood what those who wrote it and those who ratified it and those who discussed it had in mind when fashioning it, but disagreed sharply with the Constitution, believed that it was a flawed document. And certainly there were people, as her research indicates, who felt that. That doesn't mean that they interpreted the Constitution differently. It means that they saw what the Constitution was doing and meant and decided that they didn't like it. If they then took the next step and tried to interpret the Constitution from the perspective of their dislike, they wouldn't be different, they would be wrong. Because they would be wanting to substitute the Constitution that they thought should have been written for the Constitution that was in fact written. In another place, the paper says, if public meaning originalists seek to understand the Constitution as it was understood by the public, the meanings of the entire public must be considered. Why? Why must the meanings of the entire public be considered? There are all kinds of nuts out there who believe all kinds of things about all kinds of texts. That doesn't mean that when you're talking about reasonable interpretive alternatives that you take them into account. At another point, and I'm almost finished with this small catalog, at another point I read, by incorporating more, this is page 27, by incorporating more diverse perspectives into constitutional interpretation, originalists and originalist practice can demonstrate that diverse perspectives are important and that diverse populations matter. And my question here is, matter to what? No doubt they are important. No one wants to doubt the importance of diverse populations. But what is the relationship of the diversity here documented to the issue or problem of interpreting a constitution? I don't see it. What I see here is a fusing of a sociological/historical concern with how people were positioned in relation to power and accessibility, and a normative interpretive question. And in fact, throughout the paper, there are three registers that are in operation. One, a consideration of interpretation, as most of us who think of ourselves as originalists are concerned with it. Second, a sociological account of who was or was not party to the forming of the Constitution. And third, and finally, I think most importantly, a political agenda, a wish that the Constitution and originalists would go in another direction. Which brings me to my final quotation, which is toward the end of the paper on page 67. A single sentence, which I think identifies for me my problems with the logic of the paper. Quote, by extension, originalism is undermined when supporters of an individual right to bear arms express profound concerns about particular white Americans' rights being protected, but fail to rally when a police officer shoots and kills a black man who would inform the officer that he was legally carrying a gun. I don't see why originalism, as a way of thinking about the Constitution, is undermined by this at all, or what it has, that it has anything to do with the political outrage one might feel at the events described in the second part of the sentence. This paper seems, for all of its eloquence and research in passion, in my mind, to be an instance of the bad things that happen when identity politics are let into the room.
Okay, so first, thanks for writing this paper. I want to offer maybe a more provocative variant of your procedural justice explanation for why more women and persons of color don't gravitate towards originalism. And that is that I suspect that women and minorities are less willing to gloss over the reality that the Constitution was not actually adopted by a supermajority of the people. Most normative defenses of originalism rely to a substantial degree on the notion that the American people collectively came together and gave the Constitution the force of law, and therefore were bound by its original meaning, because that's the only meaning that the American people actually collectively agreed to adopt. Whether or not those normative claims are compelling, they're factually false. The Constitution was not, in fact, ratified by a supermajority of the American people. It was ratified by a tiny subset of the landed gentry, and only something like 2.5% of the population even indirectly participated at all in the ratification process. So it always amazes me how few originalists are willing to even engage with this issue. I think that the noble exceptions to that are, for the most part, in this room or on the phone. But most originalists just kind of plow forward behind this false claim of historical popular sovereignty. I suspect that fewer women and persons of color are willing or able to follow suit and play that game, to ignore those historical realities. I can get up and claim that a supermajority of my ancestors agreed to the Constitution and adopted the Constitution, and therefore were bound to follow their understanding of what they were doing. That's not true, but I can say it, and I can probably even convince myself that it's true, because you slap a wig on me, I could be James Wilson. But Shakira can't say that. She can't get up and say a supermajority of her ancestors agreed to the Constitution. And she can't convince herself that that's true, because it's self-evidently not. She can't look at a painting of the Constitutional Convention and see herself in period clothes. And therefore, I think more women and people of color can say those people were not, in fact, representative of America. The American people did not, in fact, rally around and collectively agree to the Constitution. And I think that's a harder leap of faith for women and people of color to make.
So first of all, I want to say, again, thank you for writing this paper. I think it handles rather deftly a subject that many have found difficult to write about, and I'm very glad that it is being presented here. I have, I don't know if it would be best described as a pessimistic view, but sort of I wonder whether in certain ways what lawyers are doing is inevitably an elitist project in some way, and that originalism may be more so than others, but it's not all that different in kind. This is not my field, but my understanding is that Hilary Putnam has an idea called the linguistic division of labor, where people in America have this concept that there are beech trees, and we also think that there are elm trees, and we think that these are two different kinds of trees. But if you asked me to describe the difference between them, I would have absolutely no idea. I could not give you I think they're deciduous, but beyond that, I could not give you the first idea of what a beech or an elm tree actually looks like. I believe they exist, and I believe they exist because the botanists probably know what they are, and I'm pretty sure I'm relatively able to identify botanists if I had to. And that's how I sort of borrow their distinction between elms and beeches. I think that in a lot of ways that's what goes on in law. So this is, something can be American law because in general Americans can figure out who the lawyers are and then say, well, whatever the lawyers think is the law is sort of stands in for what we think it is. And indeed, lawyers do that too. Whenever you ask a lawyer, an admiralty question or a tax question, like, talk to the tax guy over there. Don't ask me that one. And so we ourselves incorporate by reference some smaller group, whether we call it expert or we call it elite. It's, it sort of speaks for us, not in any sort of real deep representative sense, but just that sort of that particular category of activity is subcontracted out. I think to the extent that we are looking to figure out what a society's law is, it is almost always going to have this nature, whereby people might have lots of beliefs about the law, they might feel quite passionately about them, but they also are at the same time sort of contracting out and would, in some sense, sort of the validity of their beliefs sort of hinges on what some other smaller group actually thinks. That would be even more the case in a society where their current law in some way depends on past law in an era that was sort of even more elitist, that even fewer people would know anything about today. And so I wonder whether, with regard to sort of the framing era counterpublics, it might just be that current American law doesn't take account of what they thought because what they thought doesn't stand in for the public as a whole in the way that the views of the much smaller sort of expert legal community did. If it wasn't the case, and I don't think that Saul Cornell, that you or others make the argument, that there were sort of two rival groups of lawyers, each sort of denying the existence of the other, or if it was not the case that the debate between, say, the Federalists and the Anti-Federalists was really sort of what are the appropriate sources of American law, but more, do we think that this Constitution interpreted as we think it would likely be interpreted under the existing American law would be good or bad, then it seems like we're sort of locked into that kind of a very elite project. And it's going to be, even the evidence that we do find of people from outside it will not necessarily be as useful or probative.
Thanks for all that. I'll start with Stanley. So Stanley, the sentence "diverse populations matter." Here's why from an originalist perspective. If you care about the public meaning, the meaning of the Constitution that was held by readers or people that constituted the members of the public at the time, then other populations whose words we don't read or haven't accessed or can't access still constituted part of the population that created the meaning of the words. And that's not a statement about identity politics or privileging certain groups over others, but a descriptive statement that, given that the meaning of words comes from how we use them, different populations participate in the creation of that meaning. And so ignoring certain populations may make it more difficult for us to access correctly what that meaning might have been. The sentence that you pulled out about Philando Castile, it's a sociological point, but it's important when we're trying to understand why certain populations of people today don't find originalism appealing. And it goes to this conscious bias or potential concern That if someone is saying, I believe that the original meaning of the Constitution is that there's an individual right to bear arms and that should be fully protected, but someone only mentions that when it's a white person instead of a black person, that raises the suspicion that maybe the person doesn't really believe that and that they're hiding a different kind of view. And to the extent that originalists want to say, no, this is a well-developed and correct methodology on its own, I really mean it, it's important to recognize those places where people think that you don't. Thomas, that was just really interesting, and I'll leave it at that because there's so much more to talk about. Steve, the one thing that I intentionally don't do in the paper is try to take a normative view among the different kinds of originalism, yours, original methods, original public meaning. I would say that given that the language of the law always overlies common language to some degree, there is something that this can say to different degrees to all of the interpretive views. Though I think it says more if you're Larry Solom and you think that the actual public meaning is because the public made the Constitution, it was the actual meaning and not the lawyers that is binding. It says more to that than it would to a language of the law view. And it's just sort of outside the scope of the paper, kind of taking a crack at that second normative question. But that's all. I think that's all right and interesting that you said.
Very good. Okay, we have now 14 more people on the queue, so we might want to keep that in mind. We finish at 5:30. Is that right, Mike? Yeah, 5:30. All right. So we've got half an hour for 14 more people. And our next three are Eric Segal, Evan Betnick, and Christopher Green.
Christina, thanks for writing this piece. I think it's really important. It's obviously important since there are more non-originalists in this room than women. And I include Will and Steve in that non-originalist category, but that's tomorrow, not today. Obviously, our legal culture has to deal with the issues of your paper, so thank you for writing it. Having said that, and this won't be the first time in the next 24 hours this happens, I want to talk about lawyers and judges, because we're not going to do that very much. And I really want to talk about lawyers and judges and real cases on the ground. And when we do that, why would any person of color or woman want us to go back and try to find out the most accurate understanding of the original meaning of the Constitution in 1787 or 1868 unless you're Will, Steve, or Justice Kennedy and take the position that we're allowed to do anything we want today because that's what they meant us to do. But leaving aside that view, which only Will, Steve, and Justice Kennedy hold, maybe Jack. The original public meaning in 1787 of any issue women care about is going to be awful for women. And the original public meaning of any issue that minorities care about, of any issue that we care about today in 1868, is going to be terrible. And Michael tried really hard, but I still think it's a minority view that segregation was, we can defend it based on originalism. And I just don't understand where you're going with the idea that if we all agree that the one common denominator of everybody's originalism is what did the words mean at the time they were written, however we define that. If that's what we're trying to do, unless you're with Will and Steve, this is going to be a terrible thing for women and minorities. Now, the answer might, I'm almost done, the answer might be my answer, which is judges stay out of it and amend the Constitution or vote people out of office or whatever, but that's also a minority view. So if we're thinking that judges are going to solve these problems by looking at the most accurate meaning of the words when they were written, why in the world would any woman or person of color favor originalism? It doesn't make any sense. I'd like to know what your answer to that is.
So I have a less global and more narrow comments focusing on the reasonable person, about whom I have significant concerns, but who I also think is essential to empirical inquiry as opposed to a hindrance to it. And I want to offer a brief defense of what is conceitedly a construct. Those who use the reasonable person, including myself, I think use it to capture empirical facts of the matter concerning what words mean. And we do it because we don't really have a choice. Because ascertaining the actual understandings held by numerous geographically dispersed ratifiers or members of the general public more generally are never going to be comprehensively canvassed. And you have need for some kind of a proxy. The use of an ordinary person who is familiar with salient aspects of the context of constitutional communication fits the bill. That's true in constitutional interpretation, the same way it's true in statutory interpretation, wherein both intentionalists and textualists, I think, are in the laudable habits of trying to figure out with how an ordinary, reasonably informed person would understand text. Of course, the reasonable person won't necessarily correspond precisely to any existing person, but it's enough for practical purposes, and it may reduce the error costs and opportunity costs associated with trying to capture every understanding, however idiosyncratic. If we go with, say, ordinary person instead of reasonable person, is there a possibility of a compromise or an incompletely theorized agreement, or are you committed to the proposition that we can't use an individual proxy if we're trying to capture a public understanding or meaning?
I guess I wanted to underline something that John McGinnis said near the end. I mean, he was more unambiguously pessimistic about it, but I was thinking maybe trying to make lemonade out of the lemon. So James Lindgren, his studies of ideological diversity has pointed out there is a huge correlation between ideological lack of diversity and racial and ethnic considerations. And that causes huge problems, like the relative lack of certain kinds of diversity here in the room. But one way to think of it is, well, look, I mean, it's partly problems with the larger legal elite legal culture that is producing that. It's not our fault entirely, and it's something that the larger legal world needs to think about. Encouraging other voices, and I think Christina had a line in the paper about conservative women, conservative ethnic minorities get treated like they're not real members of their gender, and that's the kind of thing that. It's going to produce a big skew, and it's a dreadfully bad aspect to it, and achieving the intellectual objectives of the academy is harmed by that kind of attitude.
I'm just going to say thank you to those three comments because I know we're sort of short on time and I want to hear more of them. But at dinner and cocktail hour, I will follow up on all of them.
Yes, indeed. Thank you. Larry Alexander, Shakira Sanders, and Jeremy Tom.
Okay, I feel like this is coming from an entirely different planet. And so I'm really trying to understand the project. So my remarks are probably going to be some amalgam of Stanley's and Eric Siegel's in this sense. So I look at the Constitution. This is, at least a large part of it is over 200 years old. It's a document. We know who authored the words. We know about some general characteristics of people in the various state conventions. We know what their general ethnicity was, perhaps what much of their political outlook was like, and the like. And so if we think that document, that thing that's in the National Archives, if it has a meaning, the meaning was infused by the people who wrote it, voted on it, and so forth. That's not, it's not an amalgam. It's like you could take, everybody's understanding of particular words and you could somehow mush them together and get a coherent meaning out of them. It was some particular people's meanings. Yes, it's a dead hand. If that's the Constitution, if that is the supreme law of the land in this country, then yes, we're ruled by the dead hand of the past. were dealt a dead hand that was mainly the hand of lots of white males, property owners, et cetera. That's the way it is. It may be an estimable document. It may have terrible consequences. That's a different matter. That's not a matter once you interpret the Constitution, then you can sort of figure out, do I like it? Is it something I'm happy to be ruled by? But notice there's no, and unless you have an alternative Constitution in mind, that is the Constitution. There's no other one. And so you can ask for people to ignore it. You can even do this sort of imaginative thing of saying, what would these marks in the document mean if they were written by, pick your favorite political philosopher or something? They would mean something different from what people in 1789 meant by them. But you can play that game. But notice that that's a game. You're making a new constitution and giving it a meaning that perhaps you find more agreeable. But the Constitution we have, if it has a meaning, that meaning was fixed at the various times it was authored, and those meanings may be good, they may be bad, they may please some people, they may displease other people, but that's what they are. I'm trying to figure out what the alternative that's being offered is. Because as far as I can tell, we have a Constitution. It has a meaning. It's not going to be something that everybody likes. It's not going to be the Constitution that any of us perhaps would have designed on our own. But there it is, unless there's an alternative I don't know about. I have a hard time figuring out what exactly the critique is that's going on.
Thank you for this very courageous project. I think it's one thing to write this and sort of present it at, a certain conference is another thing to write this and present it at this conference. So congratulations on just the kahunas to walk in here and do it. So I think about this project, and it part of me feels as if you're trying to sort of sit here and tell a room full of primarily law professors why people may not like an entire approach to interpreting law that was spearheaded and created by someone who's really important to our legal discourse in modern America. And that's a pretty big task. But I almost want you to not so much go a little bit further, but where I'm sort of struggling is this idea that, okay, women, people of color feel alienated, and much of that has to do because of this document that was written by a bunch of people who didn't have them in mind at the time it was written. But I do wonder if that misses a few important things. Right? And I don't know if these things would make the paper stronger or weaker, but one is that from the point of view of how modern day identity politics is really perhaps more of a problem than the Constitution, I think one could argue the Constitution itself was sort of the creator of the identity politics that exist in this country, at least in part. And so when we think about sort of what do women and people of color see as their place when it comes to not just originalism as an interpretive approach, but the entire Constitution itself, I think maybe it could help to sort of identify sort of a more range of the alienation itself. Is it really just that this document doesn't speak to me, so why do I care what a bunch of old dudes who are dead thought about it? Or is this document even legitimate to begin with, considering the origins of this country? And I think that could provide a broader and a deeper or more depth, a sense of this document for women and people of color that could give it just a little more depth there, I guess, for lack of a better word, as opposed to just, they don't like it, they don't care about originalism. I think that there are some deeper reasons that I think you're trying to explore here. And I think maybe providing that alienage as a range of reasons why it could be helpful. And in that sense, if we think of it as this alienation as something that's just more of than throwing the document in the trash, then it can become a little bit more useful to think about, at least in a future project, of why the rejection, right? The Constitution exists. We can't just throw it out. It's the supreme law of the land. And in that sense, I think some of the modern issues that other commenters have brought up do come to mind. I really like the Second Amendment sort of example that you have here, but I do also wonder if part of the problem of for people of color or women to adopt originalism, assuming there's a problem, I'm not conceding that, maybe also some of who are the disciples of originalism, and has that sort of created barriers to acceptance of this theory. And I'll just end on this. As a resident of the state of Idaho, I meet many who call themselves originalists, and who hold, according to them, they know what that actually means, and that's how they think about the Constitution. And yet, when you engage in some of these individuals, originalism doesn't sound that great if it leads to that type of thinking. So is there also sort of a side of this that is not so much about our founders, but the disciples of originalism? Of course, not necessarily the scholars, but the everyday man on the street who claims to be an originalist, who claims to know what it means, who's also interacting with someone who has not read a bunch of law review articles and has never read a Scalia opinion. And so I do wonder, in some ways, I think there's more going on, I guess, and I'm wondering what that is, and I like that. In the way you approach this paper, it sort of allowed me to think a little bit more deeply about what that is.
So I too really enjoyed this paper. I think it's interesting. I think you're trying to do something unique. I congratulate you on that. I don't really have any substantive critiques of your paper. I have sort of a strategic concern that the response to the paper illustrates, which is, I think a lot of originalists are going to have an ab reaction against it, and non-originalists, represented by Eric, say, why are you trying to salvage this thing? It's obviously not worth salvaging, certainly not for the constituencies you're trying to reach. And so I was a little bit confused reading it, because the first half was a sort of litany of all of the problems with originalism. I wasn't quite sure where you were going with that. And the second half is a sort of an attempt at rehabilitation, but it doesn't really fully address any of the concerns all of the concerns of the first half. And then in addition, as others have remarked on, I mean, your project is really challenging. For example, one of the suggestions is that originalists have to be wary of reasonableness. Well, that's a philosophical and also an anthropological project. Another problem is that they have to work with incomplete records. That's a problem of historical reconstruction. I don't know if you've got time in your life to get enough PhDs to do all of this work, right? And then all of those problems are especially challenging given, as we've seen, almost all practitioners of originalism are white men. And much as we think we're great at being wary of our sense of reasonableness, and being anthropological, I'm not so sure we actually are that good at it.
So thank all three of you for those comments. A quick response to Jeremy. The paper doesn't address all of the concerns because, and this maybe needs to be drawn out more, some of them are things we can address by action in the present. And some of them are just things we can argue about whether they matter or not, whether they're good enough or not. And so I left those latter ones to the side, in large part because people have tend to talk about them a lot in law review articles and other papers. So Larry, I want to talk about the different planet. I agree with you that the Constitution has a fixed meaning, and this raises, maybe this is a different way of framing the motivation for the paper. Why does all the arguments in favor of that not move very many women and people of color to be in this room right now? One point of view you might have is that all those people are just wrong and biased in favor of themselves and recognize that this isn't going to advance their interests, but that we are all thinking about this clearly and are correctly interpreting what the law requires. That seems not entirely plausible as the best explanation. And so it's worth asking, why are those people absent? And some of those reasons we might say are not valid, and some of them we might say are valid and interesting and might cause us to alter within the constraints of the fixation and constraint principle to change the way, some aspects of how we do originalism or what we care about. So this comes from the perspective of being friendly towards originalism and recognizing that there's something interesting happening here that's worth exploring and that I think needs to be dealt with in order to move forward as a methodology that can be widely accepted.
Right, our next three. Hale and Randy Barnett.
Okay, well, thanks a lot for this paper. I think this is a really interesting and challenging paper, and it's definitely got us talking, and I think it's something that originalists need to really think about. So the part that I wanted to think about was maybe what you described as the bad outcomes part of it, without diminishing the other parts of it. But I may be unduly cynical, but I tend to think that this is an awful lot of what is driving the bigger picture here. In particular, I might suggest that I'm not sure if there are a large number of conservative women and minorities who are not originalists. And based on an admittedly limited sample size, my impression is that actually conservative women and minorities tend to lean towards originalism fairly openly, and so I think it's actually. I might suggest that a lot of the results, a lot of what's being driven here is that originalism leads to bad outcomes, or perceived to being leads to bad outcomes for people who lean to the left. And there's a reason for people to think that, because originalism, for better or for worse, has been associated with conservative outcomes, and for better, in the sense that it's been pushed by one political party, which has given it a political prominence that wouldn't have if it was just some academic backwater that just the people in the room sat around and talked about. But on the other hand, it's a problem for originalism, I think, and this is why I think this paper is so important. That I think it's a problem for originalism, and it's particularly a problem for originalism as originalism has become something identified and expressed with one side of the political spectrum, is that tends to immediately turn off the other side of the political spectrum. And if the originalism project is going to have any legs beyond getting the attention of one side of the political spectrum, it needs to figure out how it can appeal across that political spectrum. And I think that puts the bad outcomes, the perceived bad outcomes part of this right to the forefront. And so it may be that problem is just irresolvable, as Eric suggests, but I'm inclined to think that it's not. I think that actually this is sort of a bad rap that originalism gets. Again, like I said, not entirely undeserved or unexpected, because it has been associated with one side of the political spectrum. But I think if one looks across the spectrum of what original outcomes can produce, you can get an appeal across the political spectrum. So one book I didn't mention when I was talking about books from last year is David Dorson's book, The Unexpected Scalia, which talks about Scalia's quote-unquote liberal results. And I have some issues with that book in other respects, but it does sort of put that on the table, that there's not an identity between conservative outcomes and originalist outcomes. And then, so what that would then lead me to believe is sort of in a what is to be done kind of spirit of your paper. It seems like that one thing that originalist academics can do is to emphasize the places where liberal outcomes can be achieved by originalist means, and especially for people who have a conservative outcome, a conservative orientation, to try to, and this I think picks up on something that John's saying, that to fight back against that bias, not just in how we evaluate particular issues, but also how we pick issues. Which issues that we're going to talk about, which issues we're going to focus on. So it might be part of the selling of originalism, as it were, is for people who are dedicated to that project to find ways to appeal across the political spectrum, and I believe that is possible, but it's at least something that I think could be explored, and something that might be emphasized more in the paper as a way of sort of, and maybe this goes to Jeremy's point about selling the paper as what is the audience, and maybe part of the audience is originalists who want to sell originalism.
Christina, I really enjoyed this paper. I think it's very interesting and important. My question or my comment was really, I guess, a suggestion. Maybe it'll lead to a question, which is to maybe, at some point in your project, I think it would be useful to look at other forms of diversity that are present at the founding. So you're really looking at the hardest cases here in many respects, African Americans and women primarily. There was a lot of diversity, as you know from your translations paper, interesting diversity at the founding that many originalists are not aware of, that many law professors are not aware of. I thought one of the most exciting parts of your paper was when we started to hear the voices of other people who we haven't heard before talking about the Constitution. I want to tell you about a couple discoveries I made recently along these lines, and that's the suggestion. I think there's more of this if you look. So earlier, I've been looking at the original meaning of the ex post facto clause. It turns out that there's a lot of evidence that people at the founding thought it had a broad application to any retroactive law, not just retroactive criminal laws. And it's often diverse individuals who are making those constitutional arguments. So I'll just give you two examples. The Indiana company, which is the company that brings Grayson against Virginia, that becomes Hollingsworth against Virginia. It's the first case that looks at whether the 11th Amendment will be applied retroactively. The Indiana company was comprised primarily of Jews, of Catholics, of Quakers. It was a kind of interesting heterogeneous mix. So the principal owners of the company who brought that case in 1790 are the Gratz brothers, the Levy brothers, the Simons, the Franks. John Shee is an Irishman. James Wilson is a Scot. It's not Anglo-Saxon Protestants primarily. Another example is that in the 1790s, when the Federalists become increasingly nativist and they pass the Alien Act, Irish immigrants are objecting to the Alien Act in part because it had retroactive elements, and they too are bringing constitutional claims against that, invoking a broad notion of ex post facto. There's an organization called the Emerald Society of Irish Immigrants who make constitutional arguments in the newspapers. And all of this, I guess, to me raises a question, which is whether it might be useful for you to look at these groups of people who are, in fact, excluded by law in certain ways at the time, but nonetheless, right off the bat, in the very early period, are fighting about the meaning of the Constitution in public fora, losing often. So both of those parties lost altogether their claims. But what that might tell us about diversity at the founding and a bridge to maybe some of the harder problems that you're grappling with, which I agree are the most important and the most difficult.
Jeremy just passed me a note that said that he thought that you might want to call your paper an originalism for non-originalists. What's that? Yeah, he asked, is that title taken? And so I just wanted to say I was very enamored with the project, and I'm going to be one of the originalists in the room that says, "You go, girl. You should keep this up and keep doing it." And I did originalism for non-originalists with the same kind of spirit, and a few years later, Jack Balkin. Who would have thought? Who'd have thought it? I mean, you never know. I mean, it's like. Now, unfortunately, he's a white Jewish male. I mean, you're casting out here. You never know exactly who you'll get. So I got a white Jewish male. I got one, but we never know who we're going to get. So my only small, teeny thing was which actually provoked by John's comment, and I hope John is still here, and that is that I have the assumption. It's just an assumption. I don't know the facts. That actually everybody understood the English language, and it didn't really matter if you were a woman or a man, and I think free blacks understood the English language, and I think slaves understood the English language. There may be some difference in comprehension as there would be today between socioeconomic classes, because some people might not have been well educated, but other than that, I just don't think there's that big a difference. I don't think there's that difference in meaning to be discovered, but I don't know that for a fact. I believe it to be true based on an assumption. I think it would be really nice if somebody actually did a comprehensive study, a work, to try to figure that out. I think maybe corpus linguistics is just the tool for that sort of thing. But I don't think it's going to change that many people's minds, but it is going to negate an argument that is consistently made about this different meanings from different communities. But what if everybody actually thought English meant the same thing? And then we get to the point where they didn't like it. Not everybody liked it, but there was not a meaning issue. So that's the only point. I think you mentioned this in passing in your papers, but I would emphasize this. I would emphasize it in the sense that I would amp it up to a 1 page instead of a footnote, in which I would say, there should be research done on this. In the list of things to do, which is what your paper is, there should be research done on this. Corpus linguistics might be the way to go, and whatever. And then that would negate at least the professed objection to it, because I think other people have said, obviously results, non-progressive results is really driving much of the opposition that is then articulated in terms of these other considerations, which isn't really the driving force behind the objection, but you have to eliminate these other objections one at a time as best you can, if in fact my assumption is correct, but maybe my assumption's wrong.
Yeah, I think that's all right. So I loved all three of those comments, and the religious diversity I think is really fascinating. The last FedSoc Liberty Fund event I was at, I got every book about religious diversity and toleration from the founding, because I was like, it's all related to this, and so I'm very excited to jump into that.
5 more stimulating questioners, but I think we've passed the hour. So, Michael.
Well, why don't we first